introductions. I've been able to speak to a number of you already to say hello, and I know there's a few friendly faces around and about, so still keep friendly. Who am I? Well, Sarah is the tree-hugging lawyer. I am not necessarily a tree-hugging barrister, but I'm perhaps getting there. I wouldn't want to steal the thunder off Sarah. But I am a barrister in England and Wales, but I'm also a barrister of the Supreme Court of the Eastern Caribbean of the Virgin Islands, which is a little bit sexier than perhaps it actually is. I'm also an arbitrator, so MCIARB after my name isn't some foxy arbo qualification that no one in the room's got. I am an arbitrator, and I'll explain what that actually means a little bit later on. But before I came to be a barrister, I had a 20-year career in industry. So I actually worked just down the road in Holborn Circus. So I like to think I've got a very realistic view when I give advice to my clients, because I understand what it's actually like being on the other side of the table. But I quit my job. I then retrained to become a barrister, and I've been loving it ever since. So I mainly practice in what we call dispute resolution. I'll explain again what that really means. My areas of practice are mainly contract, land and property, highways, planning and environment, which again is really exciting, and also arboricultural law, which a few of you will understand what that really means. If anybody has got a copy of this fantastic book at the bottom, The Law of Trees, Forests and Hedges by Sweet and Maxwell, that's a title by Charles Miners, and myself and Stephanie Hall are very privileged that we were invited by Charles to help edit the third edition, which was only out a few months ago. So that's how I got involved with trees. This is my QR code. I noticed there's been a few of those, so if you're interested, have a look at that. That'll tell you all about me. We are a sponsor today, and there's some goodies outside, so if people want to take sort of what I call knitting bags. I've got a few of Barcham's knitting bags, as a few of you probably have as well. They're all outside, but just feel free, take pads, pens, etc., and have a nice lunch on us. I'm going to talk a little bit about recent tree cases. Now, I'll really scoot over these, whether or not I was involved in some of them or not, but I'll really just go over some of those very briefly. If you want to talk about any detail of anything, please, you can grab myself or Sarah afterwards. So, trees have hit the press. The first one that I wanted to talk about was Bupa Care Homes. So this is a HSE case, so the Health and Safety Executive, who also, for those of you who weren't aware, also bring private prosecution work too. So they were fined £400,000 after a tree crushed a child who was out jogging with her father one day and a lime tree fell over. Basically, what the HSE found was that Bupa failed to provide a system of tree management, so it just was not adequate. They got no strategy. That was a situation over a number of years, so they've really failed there. And it was a breach of Section 3 of the Health and Safety at Work Act. So there's lots of legislation, and there's nuisance, there's negligence, but there's also statute that can be brought for claims in trees. And basically what HSE said, it was tragic and wholly avoidable incident, which is not what you want when you're a tree or a landowner. And also following that, of course, there is also the civil case that comes afterwards, like something after the rest of the events. Another one this year, 10th of January, council fined £280,000 after the death of a 6-year-old girl who was tragically hit by a falling tree when she was playing in a playground. That was Newcastle City Council. They pleaded guilty to get again to a breach of Section 3. They failed to identify that that tree was in a considerable state of decay. It was a willow that was in poor condition. They should have seen it, and tragically that is what happened. And of course, after that, there's also the civil case, which comes on behalf of the families who are looking for compensation for that loss. But obviously, you cannot compensate for that. Illegal felling, it's a lot in the press. Whenever we see it, there's always some tragedy befallen a group of trees. This was the situation in Anglesey, where a chap was fined £35,000 for illegal felling on the land. And I'll talk a little bit about why that has recently changed. People used to be interested in lopping down trees and selling the timber. Now, it's not as valuable to do that. It is more valuable to lop down all the trees and develop the land that's there for housing, because the land has increased in value by so much. And that was October last year. Looking at illegal felling, between 2012-13 and 21-22, Forestry Commission said they received over 4,000 reports of illegal felling going on, and only 15 of those resulted in a successful prosecution, which is an absolute tragedy. Lots of different reasons why that is, so I haven't got time to talk about that today. An average fine was about £1,800, together with victim surcharges, all the rest of that. Quite archaic, that piece of legislation was. The largest fine in England was for 12 Oaks, which is £15,000, and as I said, in Prestatyn, Wales, it was 35. Doesn't seem an awful lot of money for what was actually going on at that time. And as I said, historically it was all about timber. Now it's about, I want the land, I want to clear it, I want to build on it, thank you very much. However, in January, Forestry Commission said, illegal tree felling, no, we've had enough of that. We really have had enough of the historical legislation, and we're going to start upping the fines. So now, if you fell trees without a felling licence where one is required, number of exceptions, there is up to an unlimited fine. So the magistrates or whoever is hearing at the time will increase those fines. So it was 2,500 or twice the value of the trees that was felled in the timber value. So thank goodness that has been amended. Also, a failure to comply with a Forestry Commission enforcement notice and a restocking order is also a risk of imprisonment. Happy days, get to wear my fancy costume if somebody's got a risk of going to prison, so I get to wear my wig and gown, and also unlimited fine. Restocking and notices and enforcement notices will also be listed on local land charges, which is a hooray for those people who particularly come to me to say, I've just bought this property and I've had somebody knock on the door, can you help me? Because they didn't know about it because it wasn't on the land registry when they purchased the property. So bit of a problem for them to resolve. And it goes on. So top right-hand corner, this was Wellingborough, which is very local to me for those who know me, because I go past that site twice a day on my way to do the school run. The council says there's going to be no more felling till August, and that was in March. The trees are still there, those that are still standing, so we wait and see what's going to happen there. Natural England are very interested in tree felling at SSSI sites, and rightly so they should be, and that was just 20th of September. And I think everybody's heard about the 131 trees that were felled. Bromley Council taking that very seriously and issuing a replanting order, which could be quite expensive. There's quite a lot of detail on this, but I think there's going to be slides that will be circulated afterwards. This is an interesting one, just because it was an application by the defendant to discharge an interim order. So there's a tree standing, a street tree, and the defendant wants to discharge that interim order that they can't fell the tree. But the history goes back to 2014, so really, really long one here. There was no engineering solution. This is a subsidence case, and the insurer A, shall we say, if you're interested, look the case up, the names are all there, threatened legal proceedings against the defendant, so our London Borough of Haringey, and the local authority said, oh, okay, yeah, we'll take the tree out. But March, April, July, there was activity around the tree because there were protesters who protested against the plan to fell the tree, and there was a lot of activity that happened around the tree. There was an injunction to have the protesters removed and get the possession back of the tree. But in July, Mr. Brenner, so a third party who was one of the insured in one of the properties, filed a complaint to the Financial Ombudsman saying, well, I don't really like this because insurer A and insurer B, who was another property, sought to pressurise the local authority to remove the tree, and that's not very nice, instead of dealing with the underpinning, because it's really expensive and that's why they did it. So that was really important in this particular case, and it goes on, because in December when there was a hearing, the local authority agreed not to fell the tree, and everything seemed all right because they were waiting for the result of the Financial Ombudsman complaint. However, they made a plan to fell the tree on the 16th of March this year. Well, Mr. Brenner didn't like that and made an injunction application, quite right. So the court said the defendant's decision to fell the tree in March was unlawful because they failed to consider a number of matters, including desirability to await another report as a result of the complaint, because it was an important factor. So the application also wasn't made out of time, because they were arguing, well, you know, we made the decision to fell the tree last year, you know, they're out of time, they're out of time. Well, they're not out of time, because the decision to fell the tree was going to take place on the 16th of March, so the decision was pretty soon thereon, so they weren't out of time. But why is it even interesting? It's interesting because it shows that even today, right now, there are third parties who are being interested and getting involved in matters concerning trees, particularly subsidence and removal of trees. Okay. What you take from that is the public interest is growing. HSE, Forestry Commission, local authority can all bring criminal prosecution, so it's not just civil cases. Civil cases on the rise, as Sarah alluded to, 78 weeks. And I believe that's not 78 weeks from start to completion, that's 78 weeks to get your first appearance. So it could be years. If you see what happened in Hoyland, Hampshire, that incident happened in 2017. There wasn't a judgment on that till 2022. And that's without it even being appealed, for example. Trees are getting bigger, they're getting closer to people. Land is very valuable, as I've talked about. Trees in legal disputes are definitely growing, and litigation equals money. Costly, very, very costly, and also reputational damage. So, tree disputes then. Martin talked quite a bit about this. I tried to summarise it. Nuisance can be insects, berries, birds pooping on cars. You know, people don't like that. Branches fall down, they hit houses, etc., block light, hedges. A lot of activity going on with hedges at the moment. Local authorities don't seem to really understand the legislation about it, but people are definitely doing things, naughty things to hedges, and they shouldn't be. Negligence, property damage, subsidence, and also personal injury we've talked about. Planning, trees are in the wrong place, so let's just mow them over, shall we? Works to protected trees, so whether it's TPOs or in a conservation area, all that is on the rise. People saying, oh, didn't know about that. Criminal, antisocial behaviour, yeah, it's back. High hedges, we all remember that, starting to come back. Used to see them probably once every couple of years from a local authority, where local authorities are starting to get all of this now back because the high hedges are getting higher. Contractor fees are getting more expensive. I had a quote the other day for my hedge, £3,500 to top it. It's very, very expensive if you've got a hedge, but it's probably even more expensive for me to get an antisocial behaviour act order against me. So works protected trees again, illegal felling, and protester issues, brackets, persons unknown. And it involves a number of parties. So those of you who've heard me talk before, I quite often refer to the elusive Mrs. Miggins. People say, what does she look like? Well, Mrs. Miggins could look like that. But there are individuals who are bringing claims or they're having disputes. Joe blogs, he might live next door, he might know nothing about trees, might not care about trees. But more importantly and interestingly, we have the authority who are getting more involved in these disputes, and also third parties, protesters, etc. I like to think of disputes like spills. If you think about if you drop a cup of tea and it starts spilling over the counter, that's exactly what's happening in a legal dispute from the moment the tea is dropped, okay? Start thinking about it like that. So how, as lawyers, me and Sarah, working together on our disputes, how do we resolve these disputes? And I put brackets excluding crime, okay? That is quite excluding, but that is changing. So we litigate, go to court. We want the judge to give us an answer. Negotiation. So Sarah and I might get in a room and talk to people, or Sarah might phone people up and say, hello, I want to talk to you about this. Joint settlement meetings. Parties get in a room, they get around a table. One legal team on one side, the other legal team on the other, and that's what they do. They have a conversation about it. Could also be called a roundtable discussion. Litigation. Big problems. How long is it going to take us? No idea. Roll the dice. No idea how long it might take to get to court. Costs, costs, costs and costs, because everything's getting more expensive. Sarah and I are getting expensive because we've got to heat our houses, we've got to, pay council tax. Everything's going up, and just the whole process is going up and up and up. More experts required, etc., etc. And the whole thing, I think Martin said about stress and pressure, it is hugely stressful. This is the biggest health warning we've got for litigation, whether it's you as an expert, you as a local authority, you as an individual bringing the claim. It is mega, mega stressful. And Sarah and I can say between us, the amount of times that people have said, can we just make this stop now? Because it's unbearable at times. And also, if you think back to subsidence specifically, does anybody remember Bowl and Huntsfield, which is a big subsidence case? Property was eventually unfit for human habitation. That's what we always refer to. Well, I had a conversation with Mr. Bowl about that particular case. It took them 15 years, and it was 15 years of hell to get that resolved because they had to take it to the Court of Appeal. Absolute nightmare for them as a couple. Negotiation is about who has the perceived best case, possibly. Sarah phones the other side and says, well, I've got a better case than you. And he says, oh, have you? Okay, how much then? You know, that's about negotiation. Settlement distance I talk about. You know, negotiation, this is where I think my case is. This is where my other party thinks my case is, and that's our distance between us. That's how we negotiate to try and close that gap. Negotiations can easily collapse. People don't get on. People can't share the same airspace, relationships, what have you. It can easily go south. But also importantly, are people negotiators or litigators? Some people have been brought up as litigators, some people are negotiators. Joint settlement meetings, again, who's got the best perceived case? Who's got the biggest, baddest barrister in the room, possibly? That's how it could happen. Settlement distance is a problem. Easily lose focus in those types of meetings, and again, are you a negotiator or a litigator? And again, they're quite costly. Sometimes people might have a silk, they might have a number of counsel, they might have solicitors, they might have experts. You know, it all goes on. So as I said, litigation comes with a major health warning. See this chap here? It might easily be a woman. So this person here, that's the person that makes the decision. They don't always have as much experience as we all have in the room. They don't always have the same perspective as we had. So it is a bit of a risk. Also damaged relationships that people don't think about. If you are dealing with people on a continuous basis, so it might be supply you regularly deal with, you know, it might be a different type of contractual dispute that you've got, but involving the tree, then that's going to really kill your relationship with that person ongoing. Really high costs, expert solicitors, it all goes on. And the best bit is the loser pays the winner's costs and gets to keep their own bill for themselves. So sometimes it can be really disproportionate. I've been to court on claims where I've had to double check because the claimant's claiming £35,000 worth of damages. And the estimate in terms of legal fees on my side of things for a legal bill, not just me personally, but solicitors, experts, everything, it's £110,000 to run this case to trial. I mean, it's absolutely disproportionate. And the other side is saying it's going to cost them 125. I mean, it's just ludicrous, absolutely madness, but I have had that. And it's all about who wants to go to Vegas at the end of the day, because everyone thinks they've got a solid case, but actually there never is a solid case. We can only give you estimates on what we think your litigation risk is. So is there another way? No, there's not. End of presentation. Right, there is, otherwise I'd be finishing far too early on time. Yes, there is, because if you've got dirty spills to mop up, you need to look at getting some cleaning cones out. And you've got a few things. Court, litigation risk, time, costs increasing. Yeah, want to do it. Arbitration, private judging. So if you've got it in the contract, brilliant. A lot of forestry contracts have it already built in. So we already say, you know, what we're going to do in the case that we all have a bust up. So that's great. Somebody like me or a panel of experts sit there, hear your case, make a decision. If you don't like it, tough. That's what we've contracted to do. But it can be quite costly and requires you to have had a crystal ball to put it in the contract. Mediation, I'm going to talk about it. It's quick, simple and cost effective. So, arbitration, private judging, you've got to have a number of things. You've got to have a seat of arbitration, whether it's the UK or abroad. You need to have certain rules. The decision's final, but it is really quick. You can get a decision and you can move on with your life. Parties control the process, so they appoint the arbitrator, because it is private judging. You control the costs. You can have it down the pub. You can have it in Lincoln's Inn. You can have it where you choose to have it. You could have it on remote method as well. But it also may be costly, and it also comes into adjudication, which is starting to come into tree claims, particularly planning tree claims. Mediation. So, what is mediation? Well, I really like looking at Wikipedia because it's just an easy, simple way of understanding stuff. And I look at Wikipedia all the time. It's a structured, interactive process where an impartial third party neutrally assists disputing parties in resolving conflict. It's about specialised communication and negotiation techniques. All participants, not just one, all participants in mediation are encouraged to actively participate in the process, okay? So from that you get conflict resolution. Oh, conflict resolution, hallelujah, it's an end to everything. Third party, that's me because I'm a mediator as well. So you get a neutral person, specialised. I like tree claims, I like contract claims, I like nuisance and negligence. So I'm reasonably specialist. And it's about communication and negotiation. And that is how it works with active participation. So every person that takes part in that mediation has an active role to play. Some of the mediation myths just want to dispel because people have tried mediation and said, oh, I don't want anyone telling me what the outcome is. Well, that's not what happens in mediation. The parties agree what the outcome is. So that's not what it is. I know all about it. Tried it once, didn't work. Must be rubbish. No, you must identify why it didn't work. And these are genuine quotes that I've had from legal representatives. Oh, it's not amenable to mediation. Well, why not? As long as the parties agree, anything is amenable to mediation. People are settling estate disputes. So Auntie Doris dies and you've got 5 people wanting the estate. Those are the types of claims that are settled via mediation every single day, particularly around the outside of this property, because those are all the types of chambers that deal with them all, and that's what they're doing right now. It's complicated, yeah, and we can deal with that. That's not a problem. I've been in mediations where we've had 15 people in one room, we've had 10 in the other, we've had experts on Zoom coming from America. If it's complicated, we can deal with that. That's not a problem, but we just need to have plans in place. Oh, client would never agree to that. Well, I suggest you give advice, because hopefully after you see what the benefits are, you might be able to give that positive advice. Mediation is successfully used worldwide for even the most unpalatable of disputes. Anybody know who these guys are? Yeah? Well, thank goodness we're not going to hear about it anymore because they're going to go to mediation. And it's confidential, so we won't hear about it. Hallelujah. They're going to settle, finally, that horrible dispute about the vineyard. What a very middle-class problem to have. Benefits of mediation. This is taken from the Hong Kong Mediation Society. It's informal. You can do it in your jeans and t-shirt. You can do it down the Holiday Inn, okay? Cost effective, very cost effective. If you think about the money that you need to get the people in the room in the place that you desire versus going to court, wildly cost effective. Confidential, no one is going to know about it. No one's going to stick it on Facebook or Twitter. If they do, they'll get sued for a lot of money and people have to sign up to it. It's creative, you can decide what you do. If the parties want to settle for 50 pence an apology, that's what can be done. Improves relationships if you've got ongoing relationships and the parties determine the outcome. So what could be better than that? So, confidential without prejudice as well. So you can have conversations about anything you desire. Best bit, everyone pays 50-50. So think about the cost of the Holiday Inn. Think about the lunch. Think about the time out of the diary. And everybody bears the cost 50-50. You don't need to settle it. It's not about meeting in the middle. And that's what I keep telling people. It's not about meeting in the middle. If you want to, drop hands, which means, okay, I didn't realise I had a really bad case. Quick, let's walk away. That's what you can do. And I've had that quite a few times. Very high settlement rate. Can do it at any time, even before you issue a claim. And even for tree-related disputes, everybody's sitting there going, oh no, ours are far too complicated and technical. We've got loads of parties. Do it multiple parties. 6 parties, not a problem. Just have to have separate rooms. Quicker, if you really want to, and I have done it, 2 weeks. As long as there's a spot in the diary, get it done and dusted in 2 weeks instead of the 78 just to get your first appearance. Cheaper, it's 1 day, sometimes over 2, but rarely. More effective and creative, less stressful, and it's enforceable. So once you sign up to the settlement agreement, that's a legally binding document that you can get enforced in court. Parties can move on and they've got positive relationships. So, how effective is it? Considering people say, oh, I tried it, didn't work. 92% according to CEDA. Not according to me, but CEDA, and they're the Centre for Effective Dispute Resolution. So they know about this stuff because they do questionnaires with all the mediators that are underneath their panel. So it's really blooming effective. So what are the downsides, given it seems so good? Well, the parties need to agree to mediate. If you don't agree to mediate, then you can't do anything. You can't force somebody, get them in a room. That may change in the future, but we'll see. Someone needs to pay. I have done mediations where local authority have paid because we've had litigant in person on the other side. There are some finer details that you need to take care of to make sure it's a fair process. And as a mediator, I can advise on those, but it has been done. So local authority paid for it. We've all gone home and had a fantastic time and got a really good resolution. Can also do it online. Online is usually at no extra cost because you've got no venue charge, but it is nowhere near as effective, I can tell you personally, doing it online. But you can, and I've done them. And someone's got to pay for the cans of Coke and the sandwiches. So not a lot of downside. So 93% settlement rate, the parties shape the agreement, you can do it in 2 weeks, it's cost effective, less stress, more empowerment, positive relationships. So why on earth are people not using it? No idea. They must be crazy. But it's going to start to come. How does it really work? This is a proper whistle-stop tour, by the way. I do a mediation masterclass, but it's 2.5 hours. So this is really trying to whiz through. So it's 1 day, it's arranged quickly, neutral venue, paying 50-50. Anything is possible, but it's an end and no waiting for court. The mediator, in this case, Bo Peep, because she's really, really good at these sensitive issues and she's used to herding sheep for a living. She shuttles between the two parties, so there's confidential rooms. So ideally people have separate toilet facilities as well. Not myself, but a very famous mediator has had somebody had a punch up when they go to the toilet. So I insist upon it. It's separate toilets for each of the rooms. And the parties sit there. They have a chat, they have some coffees, the mediator comes in, talk about the issues, go away, have another chat, do your work. So you log on whilst you're there if you're a party and wait till the mediator comes back. They're trying to find information from you and convey information. But a good mediator tests what the other side thinks about their case, and they'll test you about what you think your case really is about as well. That is the challenge of a mediator. But as I say, legally enforceable in case of a breach, drop hands is available and leaves a positive relationship. But if you go in for it, choose your mediator with absolute care because shock horror, it is an unregulated space. Myself as a barrister, Sarah as a solicitor means we have rules, big rules, ethical conduct rules and legal rules we need to stick to. Mediators, no, none of that. Anybody can do a course and claim to be a mediator. That is why I positively promote mediations with legal background to it. If you've got a legal case, I think you might be better served by somebody who's got a legal background or a very, very high specialist technical background in that particular area that you're looking at. The CMC are a voluntary organisation. I'm part of the CMC, which means that I want to be regulated, so I adhere to their rules, and others are trying to do the same. So there's no statutory regulator, there's a large number of mediators, and what is the future of mediation? Well, mediation in the future might be compulsory / integrated, which means that you may need to do it. At the moment, for all claims, it's encouraged and may be considered when the case comes to court. So if you don't do it, you might have a nasty cold at the end in terms of costs. So that the judge may say, if you've unreasonably refused to mediate, you're going to pay some extra costs. So that's not very palatable. But the law is changing on that, and MOJ are putting in special rules so that parties will be forced to mediate effectively. So when you're choosing your mediator, as I said, choose with care. The prospector here is a good example. He sniffs out gold for a living, so you might want somebody who's a gold sniffer who can go after the cash there. Woody, he is an excellent man at a rodeo, so if you want somebody to go and chase bulls or herd cattle, then he's great for that. Jesse's very, very good with people. Buzz is a space ranger, so if you've got something that's very technical, I would encourage you to look for somebody who's very technical that can really understand those issues, rather than somebody perhaps who's a family mediator going to solve a dispute in subsidence. So last few slides now. I'm going to try and hammer it home now about litigation versus mediation, because When I went to a mediation as a lawyer, a light bulb absolutely switched on inside me, which is why I decided to become a mediator. So, anybody recognise these people? Yeah? No? Kim and Aggie. So Kim and Aggie had a show called How Clean Is Your House? They went around some really, really beautiful properties, didn't they? Yeah, disgusting. People who couldn't clean, people who were hoarding, etc., etc. So how clean is your house in terms of litigation? Oh, hang on. So I want you to think about litigation and mediation in terms of two household cleaners. You've got the one on the left, which is litigation in the purple, and you've got one which is mediation, which is yellow on the right-hand side. Know who this guy is? Barry Scott. Yeah? Okay, so he represents a particular brand. Other really, really tough household cleaners are available. So litigation is for really tough jobs. If you leave it on too long, it's incredibly corrosive. It's very, very expensive. So if you go down the aisles, this stuff's about £5 or £6 normally. Takes a lot of time to use it. You've got to spray it on, leave it to work and come back to it. And boy, is it a health hazard, because you've got to use gloves, you've got to use glasses, and it's an absolutely horrendous smell in the property. It kills all known living things when you spray it on, because it's usually bleach or peroxide based. And when you walk into the door, you can smell that you've actually used this cleaner. So it leaves a very bad smell in your house for a very long time. And that's the same as litigation. It can leave some real lasting damage. However, mediation is highly effective. It is multi-purpose. It is far cheaper and faster at getting rid of all those dirty jobs and horrible spills. There's a fresh smell of cleaning afterwards because it comes in grapefruit flavour, mint flavour, lemon flavour, what have you. So you can really adapt that to what you think is useful for your particular dirty job. And it leaves a very, very positive smell, that positive feeling in everything that you touch. So I would recommend mediation over litigation in everything that you can. And as I said, the world's changing. Ministry of Justice are looking at making integrated mediation the future. For small claims under 10,000, it will automatically be referred to an MOJ mediation. Those are 1 hour, free of charge, but they do a particular job for claims that are under £10,000. But that is quite a high number of what's going through the county court at the moment. It's the biggest volume of claims. So it really is a case of get on the bus now. It's not a case of just wait until you're told that you've got to do it. It really is a case of getting on the bus now before it leaves without you, because other people are absolutely doing it. So just in summary then, you can effectively resolve any dispute involving trees, anything at all, whether it's direct, indirect, parties have died, parties have been injured, injuries to property, subsidence. Flexible solution, there's a number of things within the toolkit that we can all use, and it really is about using those. Compulsory mediation is about when, not if. Training and awareness of your teams of mediation is highly effective, because then people know when it can be used. And claims are increasing, sadly, not decreasing. It's getting a little bit like America. There are more claims coming through, and the volume that's going through the court, they just can't cope with it, sadly, anymore. And it's not just civil claims, it's family claims are going through the roof. So there's a huge logjam in there. So when you think about claims, think about litigation versus mediation, and hopefully that gives you a bit of flavour for what might be the future and what you might consider for settling your disputes. Thank you.